So 91 forms released. So there were the notable forms that really had significant practice changes to them or had some clarifications in them are the AOAA, that's our assignment, AEA, amendment to existing agreement, our counteroffers. Okay, we have BCO, SCO, and SMCO. They all have something that's added in there that actually isn't a change to practice. Once again, it's just a clarification. The CC, actually, I think you're really going to like that. A cancellation of contract gives us a new dynamic. The CCPA, that's actually just our privacy addendum that used to be really long and hard to explain to people, and now it's a lot shorter. Still hard to explain to people. The contingency removal, some good stuff in there. Our notice to buyer to perform and notice to seller to perform. Buyer got a lot longer. Seller got a little bit longer, but is nice and organized. So I think you'll like that too. Really good stuff on the RFR for when we fall out of escrow. So that's a good thing. The RLAS changed dramatically. So we'll go through that one fairly quickly, but I do recommend you pull a copy of it and take a look at those red lines. So our RR and our RRR had a significant change as well. And then our SPQ has some new good questions on there, in my opinion. So let's jump into it. What I have on the screen are the red lines. So it just shows what the changes were. And that's mostly what we're going to focus on. So if we look at the AOAA, this is the form that we utilize anytime we're going to add a buyer, okay, or delete a buyer, or assign the contract altogether. So our contract has always said that we could assign, that a buyer could assign the contract to someone new. The seller would have to agree to it, but they could not unreasonably withhold consent. So the way that that translates is basically if it was apples to apples, then the seller can't say no. If it's a totally different set of circumstances and they would have to actually change the dynamics in the contract, then the seller could say no. Okay, and so that hasn't changed. What we did change in our new RPA is that you have 17 days to do that assignment at the beginning. Okay, so we're still using the AOAA. It is the best, it is the form we want to utilize because it addresses the dynamics that are involved. I know that if you've been around for a while, what we usually did was we just wrote an addendum that said, Joe Smith shall be part of contract. But we never addressed certain things like, did they sign all the documents? Was there any money that was changing hands? And these are legal dynamics that do actually have to be addressed. So that being said, then that's what this will do, this particular form. So one of the things that they added here, it's not in red, but you're going to see it down at the bottom, 1D, assignee is buyer's own trust or wholly owned entity of buyer. Okay, that's an addition because we are seeing where people are going in and let's say I'm buying a property as Nikki Coppa. Okay, then I say, oh, well, wait a minute, I really want my corporation to buy this property. And so then I'm changing it over. When we look at it, it does have a new name for the buyer. So theoretically, everything would have to be re-signed, except if it's a wholly owned entity of mine, then the signature would be mine anyway. So re-signing it just doesn't work, isn't necessary. So that's why they added that one. And then we go into paragraph number 2. Paragraph number 2 is the big one that we talk about our documents. Okay, right now it's been a fight. Prior to the release of this new assignment of agreement addendum, it's been a fight when we have a buyer added to get everything signed. Okay, and some people say, well, they don't need to, it's dad, he's not going to sue us, whatever. At the end of the day, we do need everything signed. So this particular paragraph, the default is prior documents have already been delivered to assignee. Assignee acknowledges that buyer has already provided assignee all prior documents. Okay, so let's take a situation where we have that cute couple that can't quite afford it and we need to add dad to the contract. Okay, dad now will get all the documents up front. That's your contractual documents. That is those are all your disclosures, all of that thing prior to signing this magic document that adds him to the actual agreement. The reason for that is because then there's no question about the 5-day right of rescission by California Civil Code that's afforded to a buyer. So that is going to be your default. Prior documents already delivered to a signee. Okay, if you're the listing agent, you want this because you never want to open up that 5-day door. Okay, but if you haven't been able to deliver everything, you have to do the assignment, and you can go ahead and say A2, prior documents not yet delivered to a signee. Okay, but it does say they agree to sign everything. And then if they don't, we do have a time to return assignee initial prior documents in C. Okay, so again, it defaults to initial copies of all prior documents are attached to this agreement. Okay, but it does have, you have to do it in 3 days if they were not attached. Okay, they still do have to put in a pre-approval or pre-qualification of any assignee. So that comes into play like if we are doing a corp. Okay, so ABC Corp wrote the offer. Okay, and they are going to assign their buyer rights to DEF Corp. Okay, well, that's fine. I've seen ABC Corp's money. They're doing all cash and they've shown that to me. That means DEF Corp must give me that same proof of funds. I need to be able to see that they can do it. Okay, so that's a pre-qualification or pre-approval. Then we get into effective failure to return or attach documents. If they don't give them to us, okay, and we don't have them, then the seller can give a notice to perform to the buyer. And then when the buyer doesn't sign or the assignee does not sign and return everything, they can cancel the agreement. Before, we didn't have that mechanism. We never had anything built in case somebody didn't do something. So now that is built into the contract. And then C3, that's where what was added about that wholly owned entity, where I gave the example of my own corporation. Okay, if 1D is checked, and that's this one up here. Okay, that's where assignee is buyer's own trust or wholly owned entity of buyer. Okay, if that is checked, delivery and return of prior documents is not required because it was my signature anyway. Okay, then we have the legal language that we need to say, all right, buyer assigns the agreement to assignee accepts the agreement from buyer, and they acknowledge that everybody's read it. By signing below, seller consents to the assignment. Okay, so that was added as well. All the language that needs to be in there to go ahead and have a valid assignment. Then at the very bottom of the form, it says assignment not accepted. Now remember, our contract says that a seller cannot unreasonably withhold acceptance of the assignment. However, it also says that this needs to be done within 17 days. So let's say this comes across on day 19 and seller does not want to approve of the assignment. Okay, they can go ahead and initial that it was not accepted and it was not accepted on this date. Or if it wasn't apples for apples, okay, let's say you were a corporation that was going to close in 10 days, all cash, and then you want to assign it to Joe Smith that needs 2 loans and 60 days to close. Okay, that would not be unreasonable for the seller to say no to. Okay, so assignment not accepted, the seller would go ahead and initial, and we have a spot to do that now. So that's the AOAA, and this should be used anytime that we are going to add a buyer. Okay, our counter offers, the changes to them are very, very similar across the board. Of course, we have a buyer counter offer and then seller counter offer, and then seller multiple counter offer. Okay, so I took the changes and just put them on one slide so we're not looking at the same thing 3 times. Okay, big deal, you're going to see the changes in 1A, liquidated damages and arbitration of disputes paragraphs. If either of them is not initialed by all parties, the paragraph is excluded. Okay, the actual language is in our counteroffers now, but it used to say if there are any paragraphs that must be signed by initialed by all parties, and they are not. They realized that the only 2 that applied to was liquidated damages and arbitration. So now they changed it to actually say that. But remember, when we're looking at, that seller sends over their counteroffer, and sometimes we get a listing agent that doesn't want to send back the signed RPA, that's an issue because If the buyer wanted arbitration and liquidated damages signed, then if they can't see the RPA, they don't know if it has in fact been signed. If it hasn't been signed, then guess what? We've got an issue there, and it's automatically countered out unless you address it in your counteroffer. So it's definitely something we want to make sure we get over there. I understand that oftentimes we have a lot of offers coming in on things, and it's a lot to initial, but we need to kind of take a step back and go, wow, it's electronic signature. This really isn't that tough, and do the right thing so that we can all look at it and make sure that our clients are getting what they're asking for. 1D used to be like two little things. The following documents are incorporated into the seller counteroffer, and it was an amendment and then other. Well, now they have some of the most common things that you would normally put in it as kind of a guide for us. Okay, so if I'm looking at it, so this specific list was pulled from the seller counteroffer. Okay, so if I was a seller, what are the things that I might counter with? I might say seller needs to stay in possession. So that's the SIP for occupancy up to 29 days. Seller purchase of replacement property. Okay, look, I got to buy something to sell this to you. So that's form SPRP. Okay, maybe they say, look, you didn't realize there is a tenant in the property right now. So let's go ahead and incorporate the TOPA. That's our new form, tenant occupied property addendum. Okay, or the release of the residential lease after sale. As the seller, I'm going to stay for 30 days or more, so I'm going to incorporate that. Then they have something on there that these two forms, the seller intent to exchange addendum and the buyer intent to exchange addendum, they're not new, but many people just didn't realize we had them. And so oftentimes we see in a counteroffer where somebody will write in buyer to cooperate with seller's 1031 exchange. Okay, well, once upon a time before we had these forms, that was okay. But when we create a form for something, when CAR puts something together, they're creating a form to solve issues that come up along the way. What if there's a problem with the exchange? Then what is the agreement between the parties? So that's why they created those forms, the seller intent to exchange addendum and the buyer intent to exchange addendum. Now they did change the form code on those. I can't remember what it used to be, but it is SXA and BXA now. So that is buyer exchange intent to exchange and seller intent to exchange. So again, very easy check boxes. When you check those are smart boxes, so it will populate into your transaction. All right, so then we go through a little bit here too. So paragraph 2, if we look at it and the expiration, okay, we have a couple ors that have been added. Once again, this isn't really a change to practice. This is something that was always the case. But what we found is that buyers didn't necessarily know this was the case. Okay, so they think, so the seller issues the counteroffer and it says they have 3 days, right? So the buyer oftentimes thinks the seller can do nothing during that 3-day period. And what do they say? Let me sleep on it. We're going to think about it. We're going to try it. We're going to, figure this out if this is going to be right for us. So what they want to make sure is clear is that it expires 5 p.m. the 3rd day. Okay. Same thing that we did previously. Or we get a signed copy back, right? Because then it doesn't expire. We're moving forward. Then we go into, or if seller withdraws the seller counteroffer anytime prior to buyer's acceptance. Okay. Now it does say by communicating withdrawal to buyer or buyer's agent. Verbal is okay per PSAR legal when you're withdrawing something. However, in our business, we always want to document everything, right? Because that's what we can prove. So there is a form, and it's the funnest form in the car library. It is the woo, and you can use that to go ahead and withdraw that counteroffer in writing. But if you know that the seller is going to withdraw and time is of the essence, because again, it's anytime prior to buyer's acceptance, you can pick up that phone and you can do it verbally. Make a note, then go ahead and send your woo. All right, and then we go to 2C, or if seller accepts another offer. Okay, oftentimes buyers think that if I just have a SCO out there, okay, it's not a multiple, it's a seller counteroffer, and it's sitting there and the buyers are thinking about it. Seller gets another offer that they want to go ahead and accept. Oftentimes buyers believe that they can't do that. Well, that's not the case. Okay. Once again, the seller has the right to accept any other offer prior to the buyer's acceptance of the seller counteroffer. Okay. So again, it's just clarity. None of this has changed, but it's something that you can help with when your buyer says, well, okay, we want to sleep on it. Understanding that that's fine. You can sleep on it, but do understand that they can accept something else in the meantime. Okay. And then we have something that has come up a lot actually recently, where we see that, and let me give you an example. So the seller issues a counteroffer. Buyer submits an RPA. Seller issues a counteroffer, and let's say the seller says, "I want that to be." Whoa, what happened there? I'm going to have the purchase price at $750. Buyer looks at it and says, "Oh, I think we can get another 5,000. I want to counter them back, use a buyer counter offer at 745." So they issue their buyer counter offer, and the seller says, "I'm done negotiating with this person. Forget about it," and doesn't want to respond. Then the buyer says, "Never mind. I'm just going to go ahead and sign their counter offer that they sent over to me." Okay. Under contract law, you can't do that. So 4 was added to make it very, very clear. Okay. By making this counteroffer, any previous offer or counteroffer can no longer be accepted. So when the seller counteroffer comes over at 750, as soon as that buyer issues that buyer counteroffer at 745, 750 is off the table. It's no longer something that can be accepted. So they're trying to make sure that people understand, as soon as you make a new offer, the other party is not bound. Same way with a buyer counteroffer. So the same thing does pop up in both of these. And you're going to see that this is also a change that has been articulated in the RR and the RRRR. Because when we look at a request for repairs and a seller response to a request for repairs, what are those? They're basically little multiple counteroffers, right? Or counteroffers between the two parties. The buyer asks for something, the seller responds. So in doing that, that's where we go through contract law. And contract law says that once you make that counter, then the other terms are off the table. So you're going to see that same change in the RR. All right, so the SPQ, okay? One of the things that they really wanted to emphasize in the changes in the SPQ was timing, okay? When we get to timing, oftentimes people think that when they're filling out their SPQ, that if something happened in the past, it's done, it's forgotten, and I don't need to say yes to that. That's not true. And so they want to be very, very clear. There's no time limitation unless otherwise specified, okay? So when we look at documents, when they have their reports from 5 years ago, where they had inspections, they had a termite clearance, they had a roof cert, whatever, they had all of those things, and the seller has them. They're like, "Oh, well, that's 5 years ago, and I already fixed all that, so I don't need to give it to the other side." No, that's not true. Whether prepared in the past or present, including any previous transaction pertaining to the condition or repair, whether or not it's been taken care of. So we always want to have all that information. So they have changed the language in 4 and 5 to make sure that we're articulating that we want to know this history. Okay. Doesn't matter that it happened in the past and it was cured. I want to know that it happened, because I want to be able to make sure that I'm inspecting for that as a buyer. So then we go into 10, paragraph 10, water related and mold issues, water intrusion, whether past or present. That's one of the things that we're seeing a lot of lawsuits on. Okay, is yes, I had a flood, but I got it fixed, so I didn't have to disclose it. No, that's not true. Okay, whether past or present. And we want to make sure, because there are in fact mold issues. And then we have pets, animals, and pests. Okay, they changed. You'll see 11A and 11B, past or present pets on the property, past or present problems with the livestock, insects, da 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 da. Okay, then we go into neighbors and neighborhood. Unfortunately, if you've been around for a while, we've all run into that neighbor that's a problem, right? And where were we going to disclose that? And I know that I get the question a lot from my agents. They're like, "All right, so the neighbor does this. What do I say?" Okay, well, before we used to do it in 16A where it was neighborhood and it was any kind of nuisance or anything odd, right? Now we've got any past or present disputes or issues with a neighbor that could impact the use and enjoyment of the property. And I'll give you an example on that one. We had a listing where apparently every once in a while, one of the neighbors would get up in the morning and he would walk down the street naked. And then he would walk back to his house and didn't bother anybody, but it was odd. And the seller asked, should I say something about that? The answer was yes. They went ahead and disclosed it. And sure enough, when it happened, the buyer laughed and went, well, I guess it does happen, but there was no lawsuit about it. Oftentimes that's what we want to look at. We always want to say, let's disclose, because that's where we're going to avoid a claim down the road. Okay. Then we see, in the new RPA, in the very beginning, it says, buyer, you need to know that there may be differences between the name of the city and the postal mailing address and the city which has jurisdiction over the property. There's a little warning in the very beginning, first page of the new RPA. Okay, so now we have a question for that too. Is there any difference between the name of the city and the postal mailing address and the city which has jurisdiction over the property? One perfect example is the city of Bonita and Chula Vista. We have homes that say they're in Bonita, California, but they actually fall in Chula Vista. And we just had one where we had a huge title issue over it because they couldn't understand the differentiation, because the actual address said Bonita, but Chula Vista has the authority over it. So that's what that's referring to. Okay. Then, of course, we get into any past or present, smoking, vaping, any substance on the property. And we knew that we were going to see this eventually, right? Sign of the times. Any use of the property for any alterations, modifications, improvement, remodeling, or material change to the property due to cannabis cultivation or growth. Okay, some people do have grow rooms, and oftentimes they're in the garage, but we do see them in the homes as well. What happens in the grow rooms is oftentimes there are modifications that have been made that people don't think are a modification. All I did was close the vent. All I did was block the vent. Okay, well, when you're blocking that vent, then you are changing the ventilation. And so sometimes we see different mold problems or things like that. So if we know that there's a room that has been used for it, then we can ask the physical inspector to check those kinds of things to see if there's any kind of issues. So that is the new question on there as well. All right. So that is it for our SPQ. Now let's go to our notice to seller to perform. Now we don't see these very often, because what do we do as buyers? We're just super happy that they accepted our offer and we just nudge, nudge, nudge. Can you please just give me this stuff? But there are all the different things on there. Okay. And these are all the seller responsibilities. If you look at the RPA, okay, the chart, our grid in the beginning, it goes through what the seller's responsibilities are to provide, right? Well, here's the list as well. So if they haven't provided any of these things, here's what we use to go ahead and say, nudge, nudge, we need this stuff so that we can move forward. Okay. And it's not side by side like the notice to buyer to perform, because we don't have nearly as much. Everything in our seller is our contractual action. Now, our notice to buyer to perform, well, that's a whole lot more stuff. So we've got two things. We've got contingencies on your left. We've got contractual actions on your right. Okay, so they are side by side like they always have been. Okay, but a lot of it is just paragraph references. So when we're looking at a contingency, that means this is something that the buyer is to investigate. And if they don't find it to their satisfaction, they can cancel the investigation or cancel the transaction. As long as they have not removed the contingency, okay, they can cancel the transaction and get their deposit back, right? So here are our contingencies. Many people think that there's a whole lot more of them. And when we look at it, a lot of it, investigation, that's where a lot of these fall under. Seller documents, condominium HOA docs, leased or liened items, all of those things fall under that buyer investigation. But one of the things that we found is that CAR wanted to break these out so people would not remove the investigation contingency when certain things had not been investigated yet. Oftentimes maybe I did the general inspection and I'm happy with the home, but I still don't have my HOA docs. So I don't want to remove the entire buyer investigation. I'll remove part of it, but not the HOA docs. So that's why they're broken out the way that they are in the contract and in your notice to buyer to perform. And then we go into contractual action. Wow, look at that. We've got so much going on. We had to go to AA, BB, and CC. So looking at our contractual actions, once again, if you look at the grid, okay, look at our grid in our new RPA, you're going to see that this lines up, okay, item for item. So that's why they did the grid. That's why they changed the contract to make it a little bit easier for a buyer to be able to look at it and see what their responsibilities are and what their timeframes are. Okay, see all the references to paragraph 3. If you look down the list, that's because that's where our grid is. Our grid has those timelines in it, right? So we've got all of that in there. And then of course you can write in anything else. All right, contingency removal. So contingency removal changed dramatically in June, in the June release. And that's where they broke out more of the investigation of property. If you've been around for a while, once upon a time, we just had investigation of property and we just removed it or we didn't, right? Now the investigation, the RPA has broken that out into different sections to make sure that the buyer's not removing contingencies before they have received all the information. So it's still 2C is investigation of property contingency, right? We can say the whole thing in 2C1, or we can say only the part concerning the physical attributes. So I'm talking general inspection and maybe my lead-based paint and wood destroying pest. Okay, maybe it's all investigations other than the physical attributes. So that means that I went over title report, I went over everything else, right? Entire buyer investigation contingency except is C4. So oftentimes when we look at certain things like that, that's where we may have in insurability, especially in high fire severity zones or very high fire severity zones. We may be looking at an insurability question. And if that's the case, we could take everything away, but we're still waiting on the insurance companies to let us know what a quote would be for that particular area. Okay. Review of seller documents. Maybe there's something that they haven't given to us and we're still waiting on that. Look, I'll remove certain things, but at the end of the day, you haven't given it to me. I'm not going to remove the rest of it. I didn't get a title report. I'm still waiting on my HOA docs. Okay. Any of those things. Leased or review of leased or liened items. That's going to be an interesting one. One of the things you have to think about on that is any of our solar stuff. Okay. So when you go out to a home and it has solar, understand that a solar property typically has at least 2 contracts on it. One that pertains to the equipment and one that pertains to the power. Okay. Sometimes there's also a maintenance agreement. So sometimes there's 3 different leases, liens, contracts, whatever, that the seller needs to get over to the buyer. Well, oftentimes the seller can't find those, right? So then they ask the leasing companies, they ask the companies that are in charge of those to get that information over to the buyer. Well, if it doesn't happen in that first 7 days, maybe we still don't have all that information. So the buyer does get their time to look at all of that and make sure that that works for them. Okay, so that's in there. Then we go through kind of reiterating something. What we were seeing is that in the time where we had multiple offers on a property, the buyer was saying, I will submit this offer with no contingencies. And the thought process of the buyer and the agent was that if I say there are no contingencies, buyer still gets 5 days to review everything and can then cancel and get their deposit back. Well, that's only true when it comes to statutory disclosures. And that's because of the 5-day right of rescission under California Civil Code. In our contract, if I say all my contingencies are removed, and then I get my HOA docs, which does not fall under the statutory disclosures. Okay, I get those HOA docs and it says nobody named Nikki can live here. Okay, well, now I have a problem. I cannot say I'm going to cancel based on that contingency because I removed it. Okay, if you remove a contingency prior to satisfying yourself in reference to that contingency, then guess what? you don't have the contingency left to cancel on. Okay. And then there's a note in this one, and that you're going to see a similar note in your RR and your RRRR. Okay. If this form is attached to a request for repairs, okay, or an RRRR or an ADM or an an AEA, it is valid. It is only valid if buyer and seller agree to the requests made on that form or document. So when we look at our RR, it's issued and it says, in response, we will go ahead and remove the contingencies on the attached RR, right? Or on the attached CR. Well, agents were always very itchy, very scared to give that attached CR, because at the end of the day, are they going to say that they're removed? It's taking away that negotiation power. So they wanted to clarify, and this was always the case, but once again, it's a clarification. This form is, if it's attached to something else, it's only valid if the seller signs off. So I do a request for repairs, seller agrees, signs off on it. Now my CR is valid. Okay. The seller doesn't agree, my CR is not valid and it can't be used against me. All right, so cancellation of contract, release of deposit, and cancellation of escrow, CAR Form CC. Again, the top portion, paragraph number 1 deals with the contract and has not changed. Paragraph number 2 is what has changed, because of course there's always been that question of, if the buyer won't sign off on canceling escrow, can that seller actually resell the home? Can they sell to someone else? There's a great CAR legal sample letter in the library. If you haven't explored the sample letters library in Zip Forms, there's actually some really good letters in there that give you some of the legal repercussions of things that we're not allowed to talk about because we're not lawyers, but you can use the letters and provide those to people so they have a better understanding of what could go wrong. Okay, but so we've got our big changes come in 2C. Although actually I think one of the best things for agents is 2A, purpose of paragraph 2. Okay, it's used to instruct the escrow holder to cancel, okay, and what to do with the deposit. The biggest thing is that last sentence. It has no effect on the cancellation of contract pursuant to paragraph 1, even if both parties don't sign. Okay, so that cancellation, if you did the cancellation correctly and per the terms of the contract, that cancellation of the contract is done, which means the parties can go get into other contracts. Okay, release of funds is not automatic. We have a reminder that there's $1,000 civil penalty that can be that they're subject to if they don't sign the instructions, if there's no good faith dispute as to the deposit. Then we go through 2C, full release, buyer and seller cancel escrow number with blah, blah, blah. Okay. C1, seller authorizes release of buyer's deposit to buyer. Okay. C2, buyer releases off the deposit to seller. And then C3 is what we do. We oftentimes negotiate. It's a $20,000 deposit. Seller feels buyer wronged them, but seller doesn't want to go after the whole thing. All they want to do is take a little bit to make up for the 30 days of payments they're now going to have to pay. So buyer says, okay, that's fine. Out of the 20,000, I'm going to release 4,000 to you and the rest comes to me. Okay, oftentimes those are the negotiations that we go through to settle a dispute. So we now have 2-3 to do that. Okay, then we get down to some clarifications, partial release and reservation of rights. Okay, this is the important part for everybody to say. The parties mutually release each other from any obligation to buy, sell, or exchange the property under the agreement. That is key to answer that question. Can the seller go close escrow with another buyer? Okay, there's always been that, well, they can, but technically there's a legal argument that they could go after them. So with this mutual release, that removes that legal argument. So that's why CAR put it in there. Okay. And then one of the favorite things that I have in that they wrote in here, scope of broker duty. Agents are not qualified to provide any opinion on who is entitled to the deposited funds, whether a cancellation was made or whether a cancellation was made in good faith. Buyer and seller are advised to seek the advice of a qualified real estate attorney. The reason why is our RPA says this, our cancellation of contract says this, our CR says this. We say it over and over again, but yet it's one of the most common questions we're asked as agents. The buyer's going to cancel and they say, well, if I cancel, do I get my deposit back? And they're expecting yes or no, right? Seller says, well, if they cancel, can I keep their deposit? They're expecting yes or no. And in the past, we've always said yes or no, because we look at the contract and we say, well, under the terms of the contract, yes, you would get it. But one of the things that's really clear in our new RPA is that it states we're not qualified to determine if a cancellation was made in good faith. The people that are qualified to make that judgment are judges. Okay. So because we're not judges, what we can say is that, well, according to all the terms, it looks like you would get your deposit back. But at the end of the day, I cannot tell you that, because the only one that can tell you for sure whether you get to keep the deposit or whether you get your deposit back is a judge if it goes to that. Okay. So I like that they added that in there. All right, so our request for repair. So when we're looking at our request for repair, they did add some things for FHA and VA loans. And that's because Form FVA, that's been in the library since the short sale periods, has been removed from the library because nobody was using it. Okay, but the FHA and VA, sometimes we do have lender required repairs, right? And so they want to make sure that there's a section for us to call those out and say buyer's FHA or VA lender requires these things. Buyer's not asking for it. Buyer's not being picky. Buyer's saying, look, the only way I'm going to get the loan is if these things are done. So it's a place for the buyer's agent to section it out for the buyer to specifically say, look, they're not asking for this. It's the lender. It's not the buyer's fault. Okay. Now, one of the things that we have that's new on our request for repair and our RRRR is expiration. Buyer proposes this request for repair, which shall be deemed revoked. Once again, 5 o'clock on the third day. Same as our counteroffers, right? Now, when we look at this, we've never had expiration before, because this contract still states the seller has no obligation to even respond to a request for repairs, right? But what does the buyer do? The buyer sits there and twiddles their thumbs and gets very upset that they're not getting a response. So at least by doing this, we have an expiration date that, look, seller, if you are going to respond, you need to respond within these 3 days. Okay. Then when we look at it, once again, remember when I said in the seller counteroffer that there was clarification that as soon as you make a counteroffer, that it rescinds the previous offer that was out there. Same thing. Buyer makes this RR on the terms above and acknowledges receipt of a copy. By making this RR, any previous RR or seller response, the RRRR, can no longer be accepted. So if you ask for 10 things and the seller says, I'll do 7, and you say, I really want 1 more, and you go back to the well, the 7 are off the table. Remember, it's the bird in the hand. As soon as you make another request, then the other acceptance is no longer on the table. Okay. So again, same thing where the seller responds to the same things. If the seller is making the response, then the previous one can't be accepted. FHA and VA, if the parties don't reach an agreement on completing the repairs that are requested by the lender, then there's a decent chance that nobody's going to be able to close the loan. Okay, so that's what's in our in those. All right, so seller response, same type of thing, right? Okay, so we're looking at it, FHA and VA, and we talk about, all right, if these are requested by the lender, then if they're not done, then we may not be able to close. So our seller response, our RRRR, okay, it now has an expiration as well. So you can see, same thing, 5 o'clock, 3rd day, effective seller request. As soon as you make this request, okay, a previous RRRR can no longer be accepted. Okay, so whatever you had out there is off the table when you make your new counter or request. All right, so the CCPA, got a lot shorter. So this is the whole thing, all the language. Used to be a whole page, now it's about a third of a page. And when this first came out, CAR Legal thought it was going to be a big, huge deal, but instead we had a pandemic, and so nobody really made a big deal about it, and it hasn't been an issue. So they have had some clarifications on it, and so now the form is shorter, but it is incorporated with everything that we do. Okay, now this is an ugly slide because I never saw a red line on this one. This is amendment of existing agreement terms. This is our AEA. The AEA was created to amend certain things like, all right, so we're going to change the purchase price, or we're going to change close of escrow. Instead of putting it on an ADM, which has no expiration date on it, okay, then we want to always put that kind of stuff on the amendment of existing agreement of terms because it has an expiration date on it. So that being said, they did put in the most common things that they see on these is the revised purchase price shall be, and you can write it in, close of escrow shall be, and then you have a whole lot of blank lines. So you will see that change to the AEA. Receipt for reports. The big thing on this one is for that person that does have their reports from previous transactions, sometimes it's hard for the buyer to understand what is what. And then we have that same property that maybe fell out of escrow. The previous buyer had 2 different inspections, okay? And so are these reports from the seller? Not necessarily. They're from the seller because of the previous buyer. So the receipt for reports has been revised to kind of give the buyer some guidance. Here's the deal, okay? All of these reports that we have, they haven't been verified by the broker or the seller. Seller had them, so seller's providing them. If you get any of these reports, Mr. Buyer, okay, if you didn't order them yourself, they shouldn't be a substitute for obtaining your own inspections. Okay, and then you see a real ugly 4. That's because that was a last minute ad. List of reports ordered by buyer or seller for this transaction. So if the seller had agreed in the RPA to get a wood destroying pest inspection, okay, that would be a report ordered by seller for this transaction, right? So we would check the A box and we would include that report. And then there's a list of all the different ones that we see a lot that are the normal inspections. You can check the box. And again, that's for this transaction. Then we go on to paragraph 5, list of reports from previous transactions. Okay, this could be they just bought 2 years ago and now they're selling. And so here are all their documents. Okay, or it could be I've had 6 different buyers on this and they've all dropped out and each one got a physical inspection and some kind of report. So I can go ahead and document them that way, prepared by, dated, and then the name. And there's A through like Z or A through like L, but I just clip that on the screen. Okay, and they do talk a lot about reports delivered via link. One of the things that I will say is I think that CAR did not really vet how many people do this. For the most part, in my teachings, when I've talked to agents, most agents do not deliver anything via, here's my Google Drive link, go ahead and download it. They actually send the hard copy over. So it is a real PDF. So if you're sending a real PDF and that's really what you do, then guess what? Anything that talks about reports via link, don't worry about that. It doesn't apply to you. If you're saying, here's my Dropbox link, go ahead and download it, or you're saying, here's my Google Drive link, go ahead and download it, then these apply to you, which I've found to be a very, very small percentage of our population, at least in our areas. Okay. Then, of course, we go into additional investigation recommendations. Look, buyer, if you're seeing that the physical inspection says that you should contact a plumber, then you should do that. You should contact a professional. Don't look to me, the seller, to see if, or the broker to see if you should do that. That's not our job. Okay. And reports prepared for persons other than buyer. Oftentimes a buyer thinks that if they get a general inspection report from ABC Inspections, okay, and they have that in their hand, and then there's a problem with it, that they can go back and hold ABC Inspections liable. Well, they can't, because guess what? That wasn't prepared for you and you didn't pay it. You didn't pay for it. So that's what this goes over. So the receipt for reports is very, very clear and can be very, very handy. It'll be interesting to see if people start using it because it's not used all that often. All right, residential lease after sale. The big thing in here, and I do have all of these, the PSAR has the slides, so they can send them out to you. And I did put all of the red areas on here, but basically the big change here is that this form had not been changed in years. And when you read through it, then an argument could be made that our agents were doing property management, okay? And no brokerage wants that argument to be made. As a salesperson, you're not supposed to do properties management, right? You need a broker's license for that. So that being said, and then getting involved in certain things in the property management capacity, there were brokerages that were saying that none of their agents could accept an RLAS simply because of that dynamic. So changes were made very specifically to basically make sure that this is between buyer and seller. Okay, so look, the property is going to be managed by this buyer. Okay, seller, you're staying, so you're the tenant. Okay, the buyer is the landlord. So as you look through these changes, and we're not going to hit on every single one because literally there's a ton of them. Okay, that's what you're going to see is we're going to tenant agrees to pay to the security deposit. Look, our agent's not going to touch it. Okay, if there's any supporting documentation for anything, then the tenant is going to get that information over to the owner of the property, which is your buyer at that point. If the security deposit is held by the owner, okay, once again, broker's not going to get involved in this. Tenant agrees not to hold broker responsible for its return. Okay, again, our people were getting pulled into these things, and it was never intended to be an actual tenancy agreement and some property management. Parking has been a big, huge issue. So they made a lot of changes in there, storage. So once again, a lot of this was just updated for current times. Our previous RLIS never talked about anything with sub-metering, gas meters, electric meters, any of that. So all that's been updated. Condition of premises, we're definitely seeing a lot where a buyer is not doing a final walkthrough because the seller is going to stay for 45 days. And then after those 45 days, the buyer feels that the property has been trashed. So condition of premises, there's some nice little walkthroughs of different things, options for the buyer and seller to make sure that they're on the same page so that the premises are actually turned over in the condition that the buyer expects. Smoking hadn't been addressed before as far as the different things that you could or couldn't do. No smoking is your default. Checking the box, have they received the documents for the HOA? Again, if they're the seller, usually yes. Entry, there's some significant change. So our current RLAS says that oral notice is fine, 24-hour or 48-hour oral notice to enter the property. So if you're going to look at it, look at 19B. Landlord and tenant agree that 24-hour written notice shall be reasonable and sufficient notice, except as follows. So now notice for the buyer to get into their property, okay, has to be very specific. So you want to make sure that you check on that when you go to actually go into the property. Photographs and internet advertising, maybe I was a corporation that was buying it and they want to rent it out. Okay, this says, look, guess what? We're going to get in there. We do get to get in there and take our photographs, and we do get to advertise on the internet. Subletting, it goes into no Airbnb-ing it out, Mr. Seller. This is for your convenience. There is an additional ad that's going to be, this is something that CAR Legal and the Standard Forms Advisory Committee has talked about for years, is putting a cap on attorney's fees in the lease agreements. So 34, attorney's fees. Any action or proceeding arising out of this agreement, the prevailing party between landlord and tenant shall be entitled to reasonable attorney fees and costs, collectively not to exceed $1,000 by default. Okay, and this was because many tenants were threatening action against the landlords, and it was going to cost far more to defend that action than to actually just pay them off. So putting that in there was a good change. Then we have death on the premises, other material facts, and then the Service Members Civil Relief Act. Okay, then we go into agency confirmation, landlord's brokerage firm, tenant's brokerage firm. Okay, so we get to say who's representing whom. We do have all of our different things. There's a notice of right to receive foreign language translation of lease or rental agreements, and then all the different items that are going to be added to the agreement, which is your bed bug disclosure, tenant flood hazard disclosure, and your rent cap and just cause addendum. Okay, then we go into the premises being managed by the owner. This is one of the most important changes, I think. The premises is being managed by the owner, or if checked, the brokerage firm or the landlord's brokerage firm or the tenant's brokerage firm or a property management company. Okay, so that being said, getting that default in there is incredibly important. Look, don't come to me when there's an issue with this or you guys are fighting over a deposit. We're almost there. Monthly lease, a residential lease or month-to-month rental agreement. The changes on this are the statutory disclosures. There is a new one that is required after January 1st. It is the mold and dampness booklet. Okay, there is a booklet that has been issued by the California Department of Public Health, and it is called Information on Dampness and Mold for Renters in California. Okay, so it is something that is available right now online. You can download it. I imagine they are going to put it in the EPUBs and our actual zip forms library, but it will be a hard check default. Mold and dampness will be required. And then we have two other items on there under statutory. If there's death on the premises, okay, you check the box, or other material facts. And then there is a document for lease, rental, mold, and ventilation addendum. This is required, okay, per California law, and it is going to reference that you're getting the mold and dampness booklet. You can see that in item 3. That does it